So the estate is insolvent. You're handling a probate estate and it doesn't have any money. Hi, I'm Brenton Begley, attorney and partner with McIntyre Elder Law, and I want to talk today about what to do if you're dealing with an insolvent estate. So generally speaking, when someone passes away and they own assets, it could be an asset of probate or it could be an asset that flows outside of probate. So beneficiary designations. So if I put a beneficiary on an account, that goes outside of probate. Automatically passes to the beneficiary. There's no need for that asset to go through probate, so it's not an asset of the estate. So therefore, it's not an asset that the estate owns to be able to discharge any of its debts. So when you begin the probate process, claims can be made. And one of the things you have to do in the probate process is actually publish in the paper and invite creditors to make a claim against the estate. Now, they have a limited window of time in which they can make those claims, but if they make the claim within that 90-day creditor claim period, then that is a legitimate claim that must be paid. Now, those can be negotiated by, a skilled law firm, or they can be, forgiven. But generally speaking, claims must be paid. But what if there's not enough money in the estate to pay those claims? Well, if there's no money in the estate to pay the claims, then you have some options. The law affords a personal representative in North Carolina to seek assets of the decedent that passed outside the estate, to bring them within the estate to satisfy claims. So this is a really confusing thing for a lot of people, but let's try to explain it. So real property in North Carolina passes automatically from the decedent to the heirs. Now it's still subject to claims of probate, So, real property is not cleared. The title is not cleared to that property after someone passes away, even though it technically legal title passes to the heirs. You got to first figure out who the heirs are. How do you know that? Without there being some type of, right of survivorship or beneficiary designation on the deed. Well, if you don't have that, the only way to figure that out is through the probate process where you file the will or you list who the heirs are if there is no will. So if the property didn't have a deed that has some type of right of survivorship, didn't have a deed that has a beneficiary designation like a ladybird deed, then it can still be brought within the estate to satisfy claims. So what that means is if I'm the personal representative and I don't have enough money in the estate to pay the claims and I can't negotiate those claims down any further, then I have to petition the court, and the court can bring the property within the estate, make it an asset of the estate, and I, as personal representative, can sell that property to satisfy those claims. Now, look, a decedent could will their property to the estate, could direct that it be sold, and at that point it would already be an asset of the estate and could be used. But most of the time that doesn't happen. Most of the time real property passes outside of probate, but it's still subject to creditor claims. So what you want to do is you want to avoid that by setting up the property correctly to pass immediately to the heirs, not just its ownership, but also clear title. And you can do that with something like right of survivorship, maybe certain types of trusts, and with the ladybird deed that we talk about quite a bit. All right, here's the other thing that you can do if the estate is insolvent and there's nothing for you to go after. So if there aren't any assets for you to go after, like a piece of property or an account that you can go after to bring within the estate to satisfy the debts, then you still have money to pay the claims. So you pay the claims based on their priority, because all claims have priority. It might be a first-class claim, right, that you have to pay, absolutely. Like some type of claim by the government, tax, right? It could be, a cost of administration, like attorney's fees. Or it could be a sixth-class claim, like a Medicaid claim, So you got to pay it based on its priority, all right? So use what you have, pay the claims that you can pay based on the priority, and then after that, if you don't have any more money in the estate or any more assets to liquidate, then you can close the estate. And basically, those debts don't get paid because you can't get blood out of a turnip, right? So if you have questions about probate, how to avoid probate, how to navigate a probate estate, wills, trust, or anything else that we do, which is estate planning, elder law, and elder law related litigation, give us a call, 704-259-7040, or visit our website, mcelderlaw.com for your free consultation today.